Greetings to everyone coming in from all parts of the globe. It's my honor today to moderate this panel of excellence with the presence of the former Minister of Law, Justice, Parliamentary Affairs, and Human Rights of the Islamic Republic of Pakistan, Mr. Ahmed Bilal Sufi, one of the brightest jurists and attorneys of the region. Thank you again, Mr. Sufi, for having accepted to participate in this discussion. My name is Ibrahim Ati, and I am both honored and excited to serve as your moderator for today's webinar, hosted by Young ITA, the Institute for Transnational Arbitration, based in Texas. This series of project of mine is called Perspectives and Crossroads from the East. I ambition to infuse the field of disputes with fresh visions of the law. This first project today embarks us on how to enhance the established legal frameworks, which novel initiatives exist now in the field for a push on sustainability in the profession. What is the first-hand experience of the young generation working in the field, and how can established practitioners help on the best avenues for change we, the new generation, are able to push for in international arbitration? This compact session will last between 50 to 80 minutes maximum. As previously mentioned in my former panels, I would like to insist and tell the audience that understanding the complexities of the Middle East and the Global East is not just educational. It's critical for avoiding costly missteps in legal proceedings on projects within the region. It's also vital for securing successful relations with clients there. Before we get to hear the rich insight our panelists are set to share, let me very briefly and certainly extremely humbly introduce myself. My name is Ibrahim Ati. I am a young legal professional with training across both civil and common law jurisdictions in the EU and the US, and a recent proud passer of the New York Bar. My specializations lies in international arbitration, where I aspire to contribute actively and meaningfully. I have been appointed as the Young ITA representative for the Middle East region. In my mandate, I am interested in bridging legal cultures and deepening the understanding of the challenges, opportunities, and objectives practitioners can face, regardless of geography. But today is certainly not about me. It's about the incredible assembly of expertise, intellect, and experience we have on our panel. As we navigate today through today's dialogue, we have three goals. First, analyze how to freshly use established legal principles, then share the ambitious directions that the field's new generation pushes for, and then hear which avenues are best for transformative change in the field. Let's start this discussion of excellence, enriched by the rich perspectives of our panelists. Mr. Ahmed Bilal Sufi, our first distinguished panelist, stands as an authority of excellence in international law, having notably served as the former Minister of Law, Justice, Parliamentary Affairs, and Human Rights of Pakistan. His distinguished career as an advocate of the Supreme Court of Pakistan is complemented by his role as the founding president of the Research Society of International Law, where his leadership fosters an environment of scholarly excellence and legal innovation. As the senior managing partner at ABS & Co., based in Islamabad, Mr. Sufi spearheads the dispute resolution practice, steering the firm with a blend of strategic foresight and legal acumen that cements its status as one of Pakistan's preeminent legal institutions. Mr. Sufi, my first question for you would be that from the perspective of the Research Society of International Law, how can international legal principles be innovatively applied to strengthen dispute resolution frameworks globally, and what role can the society play in promoting these advancements?
Thank you very much, Ibrahim, for a very nice and a kind introduction. You have been very impressive when we met in Riyadh, and
Thank you.
It's an honor indeed for me to be on the panel and to talk about the subject that you brought up, the perspectives and crossroads from the East, emerging roads. As you mentioned, I founded the Research Society of International Law, and currently I'm also the president of the society. It's a society whose focus is on public international law matters in the region, and its teams looks at multiple disputes between G2G and G2B issues in the region, which means we have a very volatile region for several good reasons. And by virtue of that, there is a lot of trading, there is a lot of business activities at the same time. So all those things raise multiple issues relating to the contractual frameworks that parties have amongst them in the region. We also have serious political tensions in the region as well between our two neighbors, India, Pakistan, Afghanistan, Iran. And we face a lot of, I would say, we have to handle a lot of variables which are far beyond the arbitration framework. But that has given us some unique insight in terms of opting principles, in terms of finding innovative solutions, whether there are issues relating to G2G disputes, relating to even territorial disputes. The Research Society came up with an idea of creating alternative dispute resolution groups, forums, ad hoc groups, and proposed rather successfully up to a certain point how to resolve these issues that otherwise have a political overtone. With the commencement of investments by China in Pakistan, which is the Belt and Road Initiative, which is, we call it here CPAC engagement at a pretty massive level in terms of a lot of contractors coming into Pakistan of Chinese origin, documenting their companies here in Pakistan, registering them in Islamabad, Karachi, Lahore. That has given rise to a massive exposure of some very complicated issues. Then that has also further become more complex because of certain territorial concerns in the northern areas that we have the title of some of those territories because they are adjacent to Kashmir, so that raises public international law issues. With Iran, we also have some very unique legal issues, one being that we had entered into an agreement with Iran to do a gas pipeline. But since Iranian government is facing global sanctions, so Pakistan is faced with a claim from Iran for its failure to complete in time the gas pipeline, which Pakistan is finding it extremely difficult given the sanctions framework on Iran, and that is raising the level of the claim again. So with this kind of thing, and we also faced a major claim of the recording arbitration, as you may have read in the newspaper. So what Pakistan has innovated, and we have been supporting those innovations, assisting the government and those private sector entities which are part of it, is to innovate state to state and an issue to issue dispute. So it is like an alternative dispute resolution within alternative dispute resolution. So while the disputes remain pending, then there is an alternative route open to within that to make an effort to mediate and settle the matter, even if it is a pending arbitration claim or the process has been rolled out. Still, some legal steps have been taken, like innovating 2016 a specific federal law called Alternative Dispute Resolution, and then enacting some specific law for protection of foreign investment, and in that framework, creating a mediatory framework for resolving even where the claims have been taken or are being taken to the arbitration forums. So the societies has been keeping an eye on these very unique challenges that Pakistan has been facing. And then in addition to that, the implementation of the arbitration awards, since we have been a party to the 58th New York Convention, but we were quite late in doing implementing legislation in our country. Currently, we find that a very interesting development because the courts, the high courts, the Supreme Court, are coming to terms with this new regime of initially the Supreme Court judges, the conventional judges, some years ago would maintain we are an independent country and we don't care what judgments are given by courts outside us. But once you explain to them this is an arbitration award and it has a binding framework, so the courts also have to, in their reckoning, yield space to allow an implementation framework for the award. But luckily, we now have some very good judges who believe in ADR, who believe in ADR within ADR. They call it mediation, they call it offloading, even their mainstream litigation matters to mediation or ADR centers. Some centers have come up. Another strategy that I find of great attraction and interest in my region is the faith-based approach towards resolution of disputes, whether they are arbitration disputes or international litigation matters. Faith-based approach, I mean, based on the religion. Um, as you may know, that all the religions, they recommend that disputes need to be minimized and there should be an effort to resolve issues as early as possible. But for example, the recent narrative is that within Pakistan is that since the Quran tells every believer to resolve the dispute, and even it casts a duty, even if you're not a party to a dispute, you are standing outside, you can volunteer mediating a dispute because you have a covenant, if you are a believer under the Quran, whereby you will be enormously rewarded for playing a role to mediate. So there's, for example, a dispute resolution venue which has come up under an Islamic name that we find very interesting. So the faith-based approach is also a very unique development of the region as a strategy, where people are encouraged to have the issue resolved. So instead, they always think taking it to arbitration is within the faith framework, a resolution that they think will be in sync with the Quranic framework. So there is an encouragement to go to EDR or the arbitration. And if those who go into the arbitration, then there is an additional support to them to have this issue resolved based on their dictates of the faith or the persuasion that they may feel for that, even if they have to minimize some of the claims that they otherwise would want to press. So, and when you look at the international law framework in terms of Article 38 of the ICJ statute, I think it's Article 1 sub Article C, which talks about that you could have general principles of law recognized by civilized nations as a legal basis to address resolution of issues. So I believe that there is, for example, an increased traction for the OIC treaty, which was done in 1982. It was lesser known treaty. It is now viewed as a treaty for protection of investment. But then I think about 7, 8 years ago or 10 years ago, a claim was launched and those who were administering the treaty were wondering if they can entertain the claims, and then they realized they can. So now there are a few claims in the queue for that, and the Islamic Chamber of Commerce is setting up a revitalizing the OIC arbitration tribunal. I think it's coming up in Istanbul or in Turkey. So again, that is a very interesting development where you are able to persuade people, because once people go into arbitration, whether they are representing the government or the private parties, they sometimes intend to pursue it no matter what happens. There is some degree of ego involved. But when you bring in the faith-based approach, then suddenly people begin to rethink about it, and they think that could be a very good strategy to look into. And we have seen that result that has a positive outcomes to that. So I'll stop here in response to your first query. Sorry for a little longish answer, Ibrahim.
Thank you very much, Mr. Sophie, for this brilliant response. Thank you so much. The discussion is also a rare opportunity to directly learn from your expertise in Pakistani legal matters. So based on your impressive experience, I would like to ask you, as a practitioner in international law, how do you tailor dispute resolution strategies to accommodate the specificities of Pakistan legal framework? And could you illustrate this with examples of implemented strategies that have yielded successful outcomes?
Oh, well, I think the strategies being employed are primarily now being driven by some judges who are showing a lot of interest. Traditionally, as I mentioned to you, we are a common law country, and the tradition was that we would not want to step out of the conveyor belt of the judicial proceedings. But now the strategies are that some of the learned judges who believe that ADR is the way to go forward on all commercial matters including the winding up. I was assisting one of the very well-known High Court judges, Justice Jawad, and he authored a judgment precisely on these issues, that where there is a corporate matter, where there is a matter relating to regulatory framework, even that could be resolved on that framework. So we have Islamabad High Court judges who are now taking active interest at global forums. We now have judges in the Supreme Court of Pakistan, for example, who would become the Chief Justices in the next few years, taking a lot of interest and experimenting with these innovations, and exchanging notes with the colleagues the world over. That to me is a very refreshing development, because if I recall, just a few years ago, it was a very conservative judicial approach towards it, where litigation was considered the only way forward. So, with certain these important developments, I believe, and then we now have another incentive-based resolution framework coming up. Incentive being that the foreign direct investment, or the FDI, the Board of Investment, is making every effort to pursue that. So they have set up a specialized body within their own statute, and the idea is that they would encourage all removal of complaints of those who are investing, so that the matter does not deteriorate even to a point where one needs to think of going into an arbitration zone. So several layers are being brought in place, layers where complaints or grievances could be remedied instead of frog jumping to an arbitration forum upfront. So I think the strategy now is that avoid going to even a formal arbitration, and if an investor chooses to go to an arbitration forum, then really the mechanism has failed. And that is not the right way of looking at it. Appropriate strategy would be that we keep the investors engaged in discussions. There could be genuine issues on the part of the host country. Any country could have those issues. The survey being done recently explores that investors are prepared to cooperate considerably. They at times are even willing to yield to their commercial interests to a certain extent. But not engaging them creates a problem. The strategy that was creating problem was the anti-corruption legal framework, which is normally there in every country. But suddenly the scope of that got unnecessarily and unnaturally increased. So no government official was prepared to have settlement framework under the threat of being inquired into as to why the settlement has not been done for an amount even lesser than what has been agreed, and so on. So with all those complex situations, I think the judges are individually taking the initiative to bring forth these points, and I believe that this new strategy is working far better. The number of claims have dropped, and The dispute resolution mechanisms, forums, individual offices notified for that are beginning to be more vibrant. So that's where we are, and I'll stop here in response to your second question.
Thank you very much, Mr. Soufi, for those brilliant responses, teaching us more on innovative solutions in international disputes, especially in the Pakistani region and within Pakistan. Again, we are honored for this opportunity today, and we fully appreciate your time. Thank you so much, Mr. Soufi.
Thank you.
Our next panelist is Mr. Hamza Nizam Kazi. Mr. Kazi is a pivotal figure in promoting sustainable legal practices as the Mine co-chair of Greener Arbitrations, advocating for environmentally conscious methodology within the arbitration community. He practices as the head of legal and corporate affairs at Jaffer Brothers, where his leading expertise orchestrates the legal and corporate strategies of one of the most respected firms in the region. Through his roles, Hamza bridged the gap between green initiatives and corporate legal frameworks, showcasing a commitment to sustainable development and innovative approaches in arbitration and legal affairs. Hamza, my first question for you would be, well, could you please provide a comprehensive overview of the Greener Arbitrations project for the audience, for ourselves, including its protocols and tangible impacts? We would like you to elaborate on how this initiative concretely respects nature, such as the amount of paper saved, its overall impact on the global industry, and the future novel directions you are seeking for sustainability within the legal profession.
Thank you, Ibrahim, and thank you all the panelists here, especially Ahmed Saab, who have given his insight here about arbitration. Well, I represent Campaign for Greener Arbitration, and I'm the regional co-chair of the Middle East here. Well, basically, we are a group of arbitration practitioners committed to achieve sustainable change in the way in which arbitrations are managed. We promote awareness of the environmental impact of arbitrations and produce practice guides in the ways in which you can act and minimize the carbon footprint. Well, the campaign for greener arbitration began by a promise as international arbitrator by Ms. Lucy Greenwood back in 2019. It has 8 guiding principles where we work and where most of panelists as well as the participants here working in legal and arbitration arena would be aware that creating a workspace with a reduced environmental footprint by looking for opportunities to reduce energy consumption and waste. You can understand that we have to promote environmentally sustainable arbitration practices, including electronic and only submissions and correspondences via, where possible, through video conferencing and through digital means. Well, these 8 guiding principles are there, where we encourage the participants, the signatories of the Green Pledge, and we encourage all to sign this Green Pledge, where it encourages us to reduce energy and consumption and waste. Electronically correspond, where we use a lot of papers in arbitration, where now with electronically arbitration or electronically distributing the documents, it would be easier that the documents are easily handed over to the other party, and the wastage of the papers are also less in this manner. Further, we have got a video conferencing as well, where we encourage the arbitrators and the parties to have a video conferencing and as an alternative tool for traveling. Well, COVID-19 made a special, we can say, an impact on this, where we had this opportunity where most of the arbitration and when traveling was banned, the cases went on, and we did with video conferencing and all. So that is a way forward. Avoid printing and requesting the use of electronic rather than hard copies of documents. Further, we encourage the suppliers as well as the service providers who are committed to reduce the environmental footprint overall. Further, the witnesses and the experts giving evidence in the arbitral proceedings, they should be also encouraged to use video conferencing facilities, thus reducing the carbon emissions of the traveling and avoiding unnecessary travel. And finally, these travelings and offsetting these carbon emissions on arbitration and traveling. coming back, the impact, as one of the questions you have asked, well, you can imagine one of the research that we conducted as Campaign for Green Arbitration. Medium-sized arbitration nearly takes around 20,000 trees, which generates carbon emissions and equivalent to, it's nearly to complete Hyde Park, or all trees of the Central Park can be used just for one arbitration. So this is the amount of impact that arbitration, the papers and the traveling that we do in arbitration, it has an impact. So we encourage the arbitrators, the parties, the corporates that now have the green sustainability, move towards greener arbitration, thus impacting the overall sustainability. Further, we have got awareness sessions. We have awareness sessions all across the world. We have got various steering committees where we encourage the participants to encourage this green arbitration and help others to have the sign the pledge. Ibrahim.
Yes. Thank you so much, Hamza, for your presentation. I personally appreciate the initiative. It's a good thing that attorneys are also making efforts, in my opinion. I would like to thank you again for having accepted our invitation and, of course, for your time. Thank you so much again, Hamza. Our next panelist, Eugenia Stavropoulou, is an accomplished associate in the International Arbitration Department at Kim Cheng, based in Seoul. Her role at one of Asia's premier law firms involves her deeply in the intricacies of cross-border dispute resolution, where she leverages her expertise to navigate complex arbitration proceedings. Eugenia's contributions are pivotal in reinforcing the firm's standing as a leader in international arbitration, reflecting a keen understanding of the global legal landscape and a commitment to achieving the best outcomes for clients in the international arena. Eugenia, I have one question for you. As our youngest arbitration practitioner panelist here, could you please share your young perspective on the arbitration profession based on your experiences in the arbitration field? What are your plans for fostering positive change?
Hi, Ibrahim. Thank you for the kind introduction, and thank you to Young IT for having me. It is a pleasure and, in fact, an honor to join you today. So I would say this is quite a difficult question to answer. I'd like to tie this back to perhaps the growing presence of South Korea in the Arabian Peninsula, just to give a bit of a backdrop or context when it comes to how I perceive my role, especially in the context of cross-border dispute resolution. So I'm always eager to discuss Korea's involvement in the Middle East. I'm a Greece qualified lawyer. I've worked in Switzerland and I'm currently based in Seoul. And most of the work I do, in fact, has to do with parties based in the Middle East. So as you can see, there's so many different moving parts and elements to what I perceive my job to be. So it always keeps me on my toes, and I find it definitely challenging. But I think I digress. As I said before, I'd like to provide you a bit of context when it comes to the kind of growing presence that we perceive South Korea to have in the Arabian Peninsula and the MENA region in general, and particularly the GCC member states, which we perceive to have a complementary economic structure and have historically created and maintained very strong ties, primarily in the energy and construction sectors. In recent years, we've also seen these ties deepen and develop and become much more diverse and encompass various commercial, political, and other connections, which makes for a particularly engaging field to observe and operating, especially as a younger arbitration practitioner and one as myself who firmly believes in harmonization and representation in international dispute resolution. So back to my initial point regarding South Korea's strategic presence in the region. I think this revolves around basically two main objectives, at least from South Korea's standpoint. Firstly, to ensure a steady supply of energy resources to support Korea's economy, and secondly, to secure more construction contracts and increase exports between the two countries. Now, these commercial ties between Korea and the countries in the region have always been predicated on very robust state-to-state relations, which continue to evolve based on both multilateral and bilateral agreements. And we see this shape either in the form of loose memorandum of understanding or in the form of more concrete, more robust free trade agreements. And I'm not going to go into details when it comes to the exact web of relations that have developed between South Korea and the MENA and Middle Eastern countries. But it is, I think, very important to note that we've seen a lot of developments happen, especially in 2023 and 2024, and we can expect more to come, especially in the sectors of energy, construction, with a focus specifically on the green transition. As I understand, both South Korea and Middle Eastern countries try to focus on creating sustainable and green energy sources. Now, I'd say this is all evidence of a diversification trend, both when it comes to the types of disputes we can see in the future, as well as the growing interest in ESG matters, which again is particularly exciting for younger arbitration practitioners. Especially when one considers the commonalities between the countries. Now, South Korea is a civil law jurisdiction, and I believe so are most, if not all, of the countries in the Arabian Peninsula. Yet, as with some of the GCC or MENA countries, we have noted the increasing influence of common law jurisdictions and their approach to international dispute resolution, especially through the use of foreign precedents and secondary sources in court and arbitration proceedings. And this is mostly to fill either real or perceived gaps in their respective countries' arbitration laws and practices. Now, as a younger practitioner who has practiced in multiple jurisdictions, I kind of make a point of keeping track of major arbitration developments around the world, and I believe that's particularly helpful when it comes to bridging those differences and filling the gaps when it comes to practicing across border, or rather advising clients when it comes to cross-border dispute resolution. This is particularly important when it comes to practicing in countries like South Korea, and I believe in some Middle Eastern countries as well, especially since these are still considered relevantly recent or emerging arbitration jurisdictions. Many of the practices and general approaches to arbitration are still being shaped and heavily influenced by the trends in more quote-unquote advanced jurisdictions, arbitration jurisdictions like the UK and Switzerland. Now, I think Korea's growing involvement in the Middle East, certainly when it comes to mega construction and energy projects in the Arabian Peninsula, has given Korean arbitration practitioners with a very healthy understanding of and respect, I would say, for different cultures and the impact they have on behavioral patterns, which I think is a crucial skill set for conducting work across borders, especially as a younger arbitration practitioner. Of course, one must be cautious not to rely on cultural stereotypes or to generalize, but comprehending context and being willing to bridge differences is essential when working with stakeholders involved in complex and high-stake projects, especially in jurisdictions that are geographically divided, as well as being divided by cultural and other differences. Overall, I believe that the current time and circumstances provide a unique opportunity for younger practitioners to carve out their niche in international arbitration. the increasing interconnectivity between, as I said, geographically distant countries and the diminishing disparities in legal approaches create a very fertile ground for our growth. And in that context, it is crucial for us to acknowledge the role we desire arbitration to assume in diverse dispute resolution settings. I think it is important to keep in mind that arbitration is primarily party-driven, and it can be highly bespoke and adapted to the needs of the parties and the clients we represent, especially in the context of this new opportunities and challenges that go hand in hand with increasing growth, especially of countries like South Korea or the GCC member states. For example, and I believe Mr. Sufi noted or touched upon this issue during his presentation, we have noted a definite trend amongst our clients with high-value disputes in construction and energy, even investment actually, in favor of mediation as opposed to arbitration, which I think is reflective of a willingness or a need to preserve commercial relationships, and perhaps also a criticism aimed at arbitration's increasing costs. So it is definitely a role as dispute managers to keep our finger on the pulse, so to speak, and to adapt our processes and our approaches to meet the needs of our clients, as well as take into account the particularities of their counterparties. In addition, I'd say I believe that harmonization, or rather the trend of harmonization, can be a significant contributing factor in how arbitration evolves, both in the Middle East and in emerging, as well as in some of the established arbitration jurisdictions in Southeast Asia and the Greater East. Beyond benefiting from instruments that promote harmonization to establish stability and predictability in general, it can also act as a starting point for greater mobility of practitioners between jurisdictions. It is, of course, difficult, if not impossible, to achieve total harmonization, but an understanding that harmonizing should be pursued at all times, I think, provides ample opportunities to young professionals today to contribute or feel like they're contributing to and shaping the further development of international arbitration law. This is particularly important when you consider, or when one considers that removing barriers to international trade and investment also provides opportunities for young professionals to study, to research, and engage in further development of the relevant areas of law and practice. So I would say overall interesting times to be a young arbitration practitioner, especially in the Middle East, especially in Southeast Asia. So these jurisdictions have sort of grown together, especially through their involvement in various projects, especially complex construction and energy disputes. And we can only look forward to future developments as Korea and the GCC continue to foster and promote the bilateral relations. That's all for me. If you have any questions, more than willing to answer them.
Well, Eugenia, thank you very much for your time. I am very happy to hear your young perspective. It's important to also hear directly from the youth how they see positive changes in the field and to empower the next generation, which you are part of it, of course, certainly. Now, I have the pleasure to introduce you to our last panelist, Mrs. Anne Sentence. Mrs. Sentence is a partner at White & Case, New York, where her extensive leadership and expertise significantly impact the field of international arbitration. Her roles have ranged from chair of the New York's Women Network to head of the Americas Disputes section and secretary of the firm. In her capacity in the international arbitration practice, Mrs. Sentence operates both as counsel and arbitrator across a broad spectrum of arbitration contexts, including commercial, investment, and construction, under all major international arbitration rules, as well as ad hoc and regional frameworks. Her global experience and profound knowledge contribute to her strong voice and authority in the arbitration practice and global discourse. Mrs. Sentence, based on your international leadership in the field and your years of specific practice as both an international arbitrator and counsel, practitioners, and certainly me personally, value strongly your impressive experience. I would like to ask, where do you personally perceive the most promising avenues for transformative, positive innovations in disputes by the emerging generation? And what steps can we, as young practitioners, take to foster a strong advancement in our field?
Thank you, Ibrahim. It's also my pleasure to be here today. As I was mentioning before the webinar started, I've been involved in ITA, I think at this point for 20 years, and I saw the creation of young ITA, and I've seen it grown to what it is today. And I think it's truly a wonderful and remarkable platform for exchanges like today. And I'll actually come back to that a little bit later in my comments. I'm also delighted to have been asked by Ibrahim to speak about this particular topic. I think as most people who work with me know, I'm focused on the new generation. I think the new generation has a lot of promise, and I'm always delighted to see the enthusiasm of the younger generation, and I'm very happy to share my thoughts today about what I think are particular avenues for the younger in the audience to focus on. It won't be a surprise for you, having heard my background, that I very firmly believe in arbitration as an alternative to court litigation to resolve disputes, in particular when there is an international element or a particular need for a certain expertise. And here I noticed Eugenia's comment about the importance of construction arbitration, and I think their particular, for instance, I think arbitration is a really important avenue to resolve disputes. But we also have to be very mindful of the criticisms that are being leveled, some of which I think do have some basis. And I think we need to consider them very carefully to make sure that arbitration does remain a dispute resolution method of choice in the years to come. And the two key challenges that I see, one again was already mentioned by Eugenia. First, I think, is the increasing time and cost that is involved in arbitration. In a way, I think it's inevitable. Projects become more complex, disputes become more complex. And so it's I think normal that we've seen a really it's very significant increase in the complexity of dispute resolution proceedings. And I think an area that we need to really think about very carefully is how we can have a meaningful dispute resolution process that does consider the substance of the disputes without devolving into something that becomes entirely unmanageable, in particular, as I'm seeing recently for the arbitrators who have to deal with the mass of paper and exhibits and seem, I have to say, sometimes increasingly unable to deal with that. But we do want a resolution on the substance. We don't want to devolve to rough justice, and I also don't think we want to devolve to the court. So I think that's a particular area of focus in the years ahead. The second main threat that I see to the field is an increasing perceived lack of legitimacy, and that's in a broad sense. I think there's less trust in the decision makers. When I started in this field about 25 years ago, we would get an award. We would basically send a letter to the other side. Here are the bank account details to which you can pay, and it was paid. That's less and less the case, and I think we're going to see less and less of that in an increasingly dispersed world. We also see criticism on lack of transparency, leading to legal uncertainty and distrust. And also complaints that disputes are getting more and more complex, involving stakeholders beyond the immediate litigants involved in a dispute. And we're going to have to grapple with how to somehow involve the perspective of those other stakeholders without making the resolution of the specific dispute at hand completely unmanageable for the litigants and their counsel. So against this general background, I see 4 areas where I think the new generation can make a real difference. Now, these areas are to a certain degree interconnected. And you'll also see that I actually think that the new generation is remarkably well equipped to address those 4 areas. So what are they? The first area is technology. I think technology is going to be very important in the years ahead in arbitration. I think we all know we stand right now at a crossroads, at the brink of a really profound transformation that is going to come with the advent of artificial intelligence. We can also only see the beginnings of it right now, but I personally believe it's going to have a very significant impact in all aspects of life, and also in international arbitration. I'm an optimist, and so I see AI mainly as an opportunity for us to address the challenges that we're currently facing. I think AI will be able to be leveraged very significantly to reduce the cost of human effort currently involved in arbitration, and so to reduce the cost of arbitration and hopefully also the delay. And I think there's a variety of aspects where we're going to be able to leverage technology and artificial intelligence in the years ahead. I think counsel is going to be able to leverage AI-powered tools for case preparation. There's already a very significant amount of technology around for the review and the management and the use of documents in dispute resolution proceedings. I think there's going to be a significant increase in that. We're already seeing tools where you can do smart searches and basically have the document repository look for relevant documents. That's only going to increase. And I think we're going to be able to leverage technology for things like creating chronologies, summaries, and all kinds of things that we can't even imagine today. In this respect, and I am going to make some remarks specifically on the MENA region, having some experience there, I think there's definitely room for improvement in this aspect in the MENA region. There's less use of this technology today, and I think it's partly because there are technical challenges. Arabic language documents are very difficult to work with right now in the existing technology infrastructure. Very often the documents can be searched, they cannot be translated, and so I do think there's a very significant room for improvement here. And if there are any technology providers on the call, I think they should take note. There's definitely a niche there that somebody can fill. Legal research, we're already using technology to a very significant degree, but I think that's also going to increase still in the years ahead. And here also, I think in the MENA region, there is room for improvement. In many other jurisdictions around the world, court decisions are readily available and can be searched electronically. That's still not the case in many countries in the Middle East. Very often, maybe only the judgments of the highest courts are publicly available. And so I think there's significant room for improvement there. I also think AI is going to be able to be used more for case assessments and for strategy in a case. Predictive outcomes can guide certain strategic decisions, and I think we'll see more of that. So that was on the counsel side. I also think counsel and arbitrators together will be able to make more use of technology and AI in the years ahead. And I really think the younger generation is specifically equipped here because, of course, you all grew up with technology being a part of your life in everything that you do. People like me, not so much, and people who are a little older than me, even less. So I really think, and I feel that with my own kids, frankly, and my team members, that they have a fluidity with technology and AI that doesn't exist with the more senior generation. And so I think it's really an area where you can where you have a comparative advantage. So I see increased use of electronic platforms for electronic filings, for case management. Virtual hearings have already been discussed. Hamza talked about them in the context of the Green Arbitration Pledge. And I think our first speaker also alluded to them. COVID made us see that they're possible in a large amount of cases. I don't think they work in every case, but I do think they work in many cases. And I've recently been doing more virtual than in-person hearings, and I think they work very well. I would say here the MENA region is actually already fairly advanced. A lot of the arbitral institutions and laws do promote the use of technology for hearings, and I think we also see them implemented in practice. I also think that AI will be able to be used in substantive enhancing of decision making in some ways. I don't think we can entirely predict today how it will be used. And as we all know, groups of people are grappling right now with the regulation of that, what disclosures need to be made, etc. One practical aspect that I can think of is in many arbitrations over the years, I've seen tribunals ask for things like joint stipulation of facts or chronologies, which of course are very helpful to the tribunal members because they help them understand the case and also see what's in dispute and what's not. But counsel very much don't like to prepare them because they tend to give rise to dispute as to what are the agreed facts. And I can see AI playing an important role there. It's amazing how chronologies can already be compiled in a minute right now by existing technology, which in my own experience for many, many years took hours of an associate or a legal assistant to pull the documents together. So I think we should think about how we can use AI to help put together tools that can help the arbitrators with, again, seeing what needs to be decided, what does not be decided, and to help them come to a better decision in less time. So that's technology. A second area where I think the younger generation has a real opportunity is diversity. I recently spoke at GAR Live in Riyadh, and for that purpose compiled a study on investment arbitration involving the MENA region, which confirmed, not to my surprise, that the majority of arbitrators in cases involving the Middle East and Northern Africa are a very small pool of mainly white male arbitrators from either Western Europe or the US. And I also think there's still a lack of diversity in counsel in cases involving the Middle East and the larger East. I believe that the younger generation is more attuned to diversity in general, more open to it. And so I think this is an area where the younger generation will be able to make significant change. I think diversity is promoted in a number of ways. I think Young ITA is a very important example of how diversity can be promoted. It is organizations like Young ITA and meetings like we have today, where there can be opportunity for coming together, learning from each other, training, networking, and also providing a platform for younger people to showcase themselves. Like Eugenia was just given an opportunity to talk. I personally have hired experts, co-counsel, and appointed arbitrators because I saw them present at events like today. And that gave me an insight in how they present themselves and how I think they think. And so I think providing a platform is incredibly important, and is something where the younger generation, I think, naturally shines and as I said, is open to. The third aspect is an aspect that was also already discussed today, which is reducing the carbon footprint. I do think that is an area where there is still room for improvement. Picking up on a lot of the tips that Hamza gave us, I do think there are many things that we can do to have greener arbitration, and I think these tools are typically, again, come more natural to the younger generation than to some of the older generation. I'm still a bit of an exception in that I work solely with my laptop and my iPad. I do not have a single piece of paper anymore. In my generation, I think that's still an exception. I see in the younger generation that is more the rule. And I think there's generally, again, if technology, of course, is key here, but I think there's more fluidity and more openness to doing work online than there is at the more senior generation. On a more substantive front, many countries in the Middle East are aiming for a net zero situation in the years ahead. I think there's opportunities there for the younger generation as well, both in making that happen, but also in potentially thinking about the disputes that may generate. As we know, moves towards more environmentally friendly energy resources do create disputes. And I think it might be time for the younger generation in the Middle East to think about how to balance the desire to move to a more environmentally friendly way of living, really, with vested interests, which also require protection. And so to think about how that can be addressed in investment treaties, for instance, I think is a very fruitful area for the younger generation to focus on. I don't want to spend too much time, Ibrahim. I hope I have a few more minutes. Or
of course, yes. Go ahead, ma'am.
One, and then the fourth area that came to mind, and now this is particular about the Middle East, I think the Middle East has made a lot of progress in the last few years in putting itself on the international arbitration map. We've seen that first in Dubai, then there was the SCCA in Saudi Arabia, which has made very significant efforts in the international arbitration field in Saudi Arabia. And most recently, we saw the creation of the court at the arbitral institution in Abu Dhabi. And I think all of those initiatives have been very important in enhancing generally the arbitration infrastructure in the Middle East and the attractiveness of the Middle East as an arbitral venue. But I do think more can still be done. And in particular, I would say to make the Middle East an attractive venue to seat an arbitration, including with players from different parts of the world. It's still a evolving and emerging area in certain parts in the Middle East. And so I think continued education of the local bar who are interested as serving as both counsel and arbitrator in these types of cases is important. I also think that the younger generation will more naturally, again, be very suitable to handle these types of disputes. which are more international, more multidisciplinary, more multifaceted. And I think all of these characteristics are characteristics that are present naturally already in the younger generation and will make you more equipped to deal with these types of disputes. I do think work remains on working with the local courts. If you want to comfortably seat an arbitration in a certain country, you need to be comfortable that your award is not subject to inappropriate challenge before the courts. And I think there's still work to do there. Even quite recently, there was just a case in Dubai where the Dubai Court of Cassation annulled an award of legal fees in an ICC arbitration on the basis that this is not allowed under the UAE arbitration law. I personally think that decision is wrong, but I also think it's a type of decision that very much discourages holding any type of arbitration in Dubai, not only because of the specific decision at hand, but also because of the more general sign that it gives that the Dubai Court of Cassation is still not sufficiently thinking about international arbitration as a different animal than local arbitration or litigation. So I think education of judges is critical. We've seen, for those who were in Riyadh, there was a presentation there from Chris Alberti of the SCCA, who showed how they have been making efforts in the past years to educate the Saudi judiciary about international arbitration, and how he could provide some very impressive statistics showing that awards that are rendered in Saudi Arabia are very rarely annulled, and the percentages were extremely low. And I think that's the type of effort that creates confidence in the jurisdiction. And so for the younger practitioners in countries in the Middle East, I think helping with these types of efforts to educate your contemporaries and judges in general is very important to make sure that cases come to your country and hopefully accordingly come your way. So I'll end there, basically with the positive note that I really do have. I think the challenges that are ahead can be addressed, and that the younger generation is particularly equipped to address them. And I'm excited to see what's coming in the years ahead.
Thank you so much, Ms. Sentence. We are happy to learn from your expertise and for your very kind recommendations. I thank you again for helping build the bridges with the new generation of practitioners. On AI assistance in disputes, I personally think that attorneys are going to dispute the entered data in front of the arbitrators, and you may have specific jurisprudence on algorithm and internal processes of AI tools. As we have now indeed reached the end of our journey for this first session of Perspectives and Crossroads from the East, I would like to thank again the audience and to extend my gratitude to our panelists. The insights shared today not only shed light on the new Crossroads landscape, they also show novel approaches and new leadership for the practice. Thank you for joining us today. We look forward to continuing these important conversations in the future and, of course, to meeting you in the future. Thanks so much.